Pratibha, are you hearing me?
Yeah.
Pratibha, I'm making you the host for some time. And do you know how to make the host again?
We I'll call you.
Yeah. Good evening to all the participants. I welcome you all to this Rayat College of Law virtual session 4.0. I request all the dignitaries as well the participants to kindly turn off their camera and kindly mute yourself. Good evening, everyone. Since our principal, Worthy Principal Dr. Monica Sharma ma'am has arrived, welcome, ma'am. Grateful to
Thank
have
you,
you here.
Sachin.
Yes, ma'am.
Thank you, Sachin.
Grateful to have you here. A worthy dignitary of the day, Mr. Bhagyadar Mishra, advocate from Honorable Gujarat High Court, has joined. Welcome, sir.
Hello, good evening, sir.
Actually, his voice is not clear, and
Okay,
the
okay.
connection is not. He'll join just again.
There's really going to be a sit-down in various industries and within that amongst players. Industries which have a strong element of tourism or a technology related.
Good evening, everyone. Our worthy dignitary of the day, Advocate Bhagida Mishra from the Honorable Gujarat High Court, has joined. Welcome, sir. Welcome to this virtual platform, sir.
Thank you.
Our worthy principal, Dr.
Good
Monica
evening,
Sharma.
sir.
Yeah, thank you. Thank you very much.
How are you, sir?
Thank you, madam. Good afternoon. Thank you. So nice of you.
Thank you, sir, for joining us.
Yeah, thanks a lot.
It's our pleasure you have joined us.
Yeah. It's my same pleasure to join off all of you.
Our worthy dignitary of the day, Mr. Alok Jain, advocate from Honorable Punjab and Haryana High Court, has also joined. Welcome, sir. Welcome to this virtual platform.
Welcome, Alok Jain. Welcome.
Thank you, sir. Welcome to you also.
Welcome, sir.
Thank you. So nice of you, sir.
Thank you, ma'am.
So nice of you. Madam, have you seen my presentation?
Sir, had you sent that? Hello?
Hello.
Hello? Yes, sir.
Yeah. Madam, have you seen my presentation?
Yes, sir. Yeah.
It is okay. Yeah, it is okay,
Yes.
na?
Yes.
Okay, madam.
Am I audible, ma'am?
Yes,
Yes,
sir. Yes, sir, you are audible. Yes, sir.
All right.
one of the guests from Honorable Punjab and Haryana High Court, Deputy Advocate General Monica Jalota has also joined. Welcome, ma'am. Welcome to the virtual platform, ma'am. She always spares time to listen to our webinars.
Yes.
It's so great of
Good
you, ma'am.
evening, ma'am. How are
Thank you
you?
so much. Thank you. Good evening, everybody.
Thank you for joining.
Yeah. It's my pleasure.
Thank you.
Dignitary of the day, Dr. Deepak Jindal, sir. Advocate.
Good evening, sir.
Advocate from Punjab and Haryana High Court has also joined. Welcome, sir. Welcome to this virtual.
Good evening, Bhai Sahab.
Good evening, sir.
Deepak Sarab, good afternoon.
There's some net problem that the
Yeah,
correct
yeah.
that
Same
is
thing
correcting.
I've seen here. Okay. Hello, sir. Deepak Sarab, good afternoon.
Sir, he is not able to connect.
I think there is some issue in his voice.
Yeah, exactly right. Deepak Sarab, good afternoon.
There is problem in his
Problem
audio.
is- yeah, exactly right.
Deepak, sir, you have to unmute yourself.
Good afternoon, Mishra ji. Good afternoon.
Good afternoon, Deepak sir. How are you, sir?
I'm good, Mishra ji. You tell how are you?
Fine, yeah, fine. So nice.
Jain साहब कैसे हो?
बिल्कुल बढ़िया सर, आप सुनाए जी. Nice to
Good,
see
good.
you.
Same here, same to you, same for you. Looking very smart.
Meanwhile,
Good evening,
Justice,
sir.
Good afternoon, sir.
Justice Kannan has also joined. Welcome to this virtual platform, sir. Honored to have you here.
Lordship, good afternoon, sir.
Good evening, sir.
Justice Kannan, sir,
Lordship,
you have to
your
unmute
audio.
yourself.
Unmute yourself.
Unmute yourself.
Lordship, good afternoon, sir. Good afternoon, sir. Lordship.
Yeah, good afternoon. It's a pleasure to join you all.
Please, Lordship.
Do you have the permission of the esteemed panel to start this conference?
How many participants? Is very less here.
Actually,
16.
this platform is only for the dignitaries. The streaming is done to the YouTube.
Okay.
Yes. So do you have the permission of the esteemed panel to start the conference? Do I have the permission of the esteemed panel and worthy principal of Rayat College of Law to start the
Yes.
conference?
Tell me,
I
it will
think-
be my pleasure to join and find out what's happening. I would like to know what you have been doing. How many sessions have you had so far?
Yes.
And what is the audience like? Who are the persons? Are they all students of your university? let me know something about what is happening on a regular basis.
Sir, on regular basis, we are having webinars. The first webinar was on the topic of the mediation. The second webinar was on the topic of transgenders. The third webinar was on the topic of victim protection scheme. This is the fourth edition, which is on the topic trademark infringement, sir.
Wonderful.
Yes. So, I, Saksham, organizer head of Rayat College of Law, would start this conference now. No doubt every one of us is criticizing the deadly COVID-19. So true also. It has forced us to stay at home. But let's see its positive side, that it has given us this virtual platform to hear such learned personalities while sitting at home. I would now request Pratibha Nanda, our organizing head, to welcome all the dignitaries.
Very good evening, sir. Very good evening, ma'am. So starting with this session, a trademark is a company's persona and identity in the marketplace. A very good evening to all the dignitaries, all the principals, professors, and all other attendees joining us from different colleges. I, Pratibha Nanda, organizer head of Rayat College of Law Virtual Session 4.0, welcome you all to an enriching session on the topic trademark infringement. The dignitaries who took out their valuable time and blessed us with their presence are Honorable Justice Kanan Sir, Advocate Alok Jain Sir, Dr. Deepak Jindal Sir, Advocate Bhagyodaya Mishra Sir. Honorable Justice Kanan Sir was formerly a judge at Honorable Punjab and Haryana High Court. Sir served as the chairman of the Railways Claims Tribunal, Principal Bench, New Delhi. A trained mediator, Honorable Justice Kanan Sir has been actively involved in more than 50 court annexed mediation. Apart from an avid interest in the medicine and law as an interdisciplinary approach, Sir is also an expert in liability and succession laws. Sir has written a book on accidents and compensation laws. Sir is also the editor of renowned Modi's textbook on medical jurisprudence and toxicology and Mullah's Indian Registration Act. His principal declaration of assets as the first judge in India to do so brought a new paradigm for the entire judiciary to follow, and Weekly India Today named him among 20 heroes of 2009. Thank you, sir, for being with us. We are honored to have you.
Yeah, it's my pleasure.
Thank you. Our next panelist, Advocate Alok Jain Sir, is an advocate at Honorable Punjab and Haryana High Court. At the High Court, Sir worked under the able guidance in the office of Shri Hemant Gupta Sir, now elevated as Judge of Honorable Supreme Court. Sir has been working independently and have been handling important matters on company law, service arbitration, and have also assisted and have been a part of full bench proceedings. Sir is also a senior panel counsel of Union of India and also on the panel of local government bodies Punjab and associated with public sector undertakings such as MarkFed, IFCI, etc. Sir has handled extremely complicated matters for institutions like Serious Fraud Investigation Office and Directorate of Enforcement. Thank you, sir, for being with us. We're glad to have you.
Good evening to all. Thank you for your kind words of introduction.
Thank you, sir.
Respected Justice Karan, one of the most poised judge I've ever appeared before. Respected Principal Ma'am, my elder brother Dr. Jindal, my colleague Bhagodaya ji, and all the participants. I feel honored to have an opportunity to address this August digital gathering. This is a new concept of sharing and enhancing our knowledge. Today's topic, trademark infringement, is a unique law which our panelists would enlighten you with. The Trade and Merchandise Act was brought in this country in the year 1958. The old act, which was known as Trade and Merchandise Marks Act, 1958. However, subsequently with the evolution of the change, trades and commercial practices, increased globalization and digitalization in trade and in the industry, the Trademarks Act 99 came into force from 15 September 2003. The bigger picture scenario, or a frame under which these protection of intangible rights is governed and protected, can be safely said to be covered under the intellectual property laws. This heading covers 4 acts: trademark, copyright, patent, and design. They're all interrelated and separate in a way, but today we are just relating to trademarks infringement. So I'll just make sure Trademarks are distinctive symbols, signs, logos, shape that help consumer to distinguish between competing goods or services. Copyrights is an artistic work. Patent is an exclusive right or innovation. And design is an ornamental or aesthetic aspect of that article. However, today we will concentrate on the topic of trademark infringement. As a brief overview, let me start by saying what is trademark in simple words. A trademark is a word, symbol, or a phrase, or even a tagline used to identify a particular manufacturer or seller or distinguish them from the products of another. For example, trademark Nike, the shoes. Nike along with Nike shoes identify the shoes made by Nike and they distinguish from the shoes made by other companies like Reebok or Adidas. Or we can use the word tagline like of Cafe Coffee Day, a lot can happen over a coffee, which you listen to every day. The main purpose of trademark is to help people recognize the source of particular good or service. The source in turn helps people determine the quality. Quality is what consumers usually base their purchase decisions upon. This is why the trademark is of extreme importance in the economy. For the consumer, a trademark reflects the source and quality of the goods or services. This is also why it is important to ensure that your trademark is not being infringed upon. A trademark represents the brand value of a trademark owner. Infringement of trademark usually causes loss of finance and goodwill to the owner of the infringed mark. So it is always better to be vigilant and prevent potential infringers from riding on the goodwill and reputation that you have established. If a party owns a right to a particular trademark, that party can sue subsequent parties for use of that trademark by infringement. The standard is likelihood of confusion. To be more specific, the use of trademark in connection with sale of goods constitutes infringement if it is likely to cause consumer confusion as to the source of these goods or as to the sponsorship or approval of the such goods. In deciding whether consumers are likely to be confused, the courts will typically look into a number of factors: strength of mark, proximity of mark, similarity of marketing channels, degree of caution exercised by the purchaser, and of course, the defendant's intentions. Trademark infringement in India is defined under Section 29 of the Trademarks Act 99. Simply put, when an unauthorized person uses a trademark that is identical or deceptively similar to a registered trademark, it is known as infringement. I'll just start. There's another concept of passing off. And broadly, the difference between infringement and passing off is if the trademark is registered, then it amounts to infringement. If it is not registered but is being used from extremely long period and is misused by a third party, it is covered under passing off. Trademark infringement is basically an unapproved utilization of a mark or administration or stamp regarding products and additionally benefits in wellspring of merchandise and potential benefits. A trademark owner who believes its mark is being infringed may take appropriate actions. Especially with the growth of this e-commerce industry, the liability of indirect infringement has also come up, which is also holds a very extremely important role and holds every person involved accountable. Thus, whether direct or indirect, any form of trademark infringement in India can attract liability. Trademark is defined under Section 2ZB of the Act of 99. And a mark can include a device, brand, heading, label, anything for that matter. And Section 103 and 104 of the Act provide for fixation of the criminal liability for false application of trademark and selling of goods. And the remedy available is under Section 134 onwards. So now I would request my other panelists to enlighten everybody with their wisdom and share whatever they have. Thank you so much.
Thank you, sir, for sharing your profound knowledge with us. So, further introducing our next two dignitaries, Dr. Deepak Jindal, sir, is an advocate at Honorable Punjab and Haryana High Court. Sir was formerly Deputy Advocate General. Sir is also a mediator at Mediation and Conciliation Committee at Honorable Punjab and Haryana High Court. Sir is a member of Governing Council, International Center for Alternative Dispute Resolution. Sir is also a guest faculty at Department of Law, Punjab University, Chandigarh. Thank you, sir, for being with us. We are obliged to have you. The next panelist of the day we have is Advocate Bhagyodaya Mishra, sir. Sir is an advocate at Honorable Gujarat High Court. Sir is a special public prosecutor to Enforcement Department, Government of India. Sir is also a special public prosecutor to Anti-Corruption Department under the statutory body of Government of Gujarat. Sir is a standing counsel on the panel of RBI, Shipping Corporation of India, Bureau of Indian Standard, ONGC, Competition Commission of India. Thank you, sir, for being with us. We are grateful to have you. I would also propose a vote of thanks to Dr. Monica Sharma, ma'am, a worthy principal, Rayat College of Law, for giving us an opportunity to organize this session. Thank you, ma'am. I would also thank our media partner, knowledge partner, the Lockit, LexPeep, and Kanuni Sahara. Now I invite Mannat, our team member, to coordinate within the session.
Good evening, everyone. Before starting the session, I would like to say if anyone has any query, then feel free to drop it in the chat box. So beginning with the session, I request our principal, Dr. Monica Sharma ma'am, to give her inputs on the topic, trademark infringement, and welcome all the honorable dignitaries.
Thank you, Mannat. Good evening, everyone. It gives me immense pleasure to welcome Honorable Mr. Justice K. Kannan. Welcome, sir. Mr. Alok Jain, Advocate at Punjab and Haryana High Court. Dr. Deepak Jindal, Advocate at Punjab and Haryana High Court. Mr. Bhagya Dya, Advocate at Gujarat High Court. You all are welcome, sir. On behalf of management, faculty, staff, and students of Rayat College of Law, on the virtual session 4.0 on the topic trademark infringement. I am sure this talk will be very beneficial to all of us. I also welcome all the participants from all over India for joining us. Thank you everyone for joining us. As we all are aware, trademark gives exclusive identity to the goods and services of an individual. However, it is necessary that the person who manufactures a good or who creates a service, he will have to ensure that it is not identical with the existing one. As we all are aware, trademarks are symbol, title, packaging, etc. Through this trademark, companies give assurance to their customer regarding their quality because it provides goodwill and image to the goods and services. For this, their protection, it is necessary that it must be registered. After getting registration, a unique symbol is given to the proprietor, and that unique symbol cannot be given to any other person. If afterwards any person tries to use that unique symbol without the permission of proprietor, then proprietor has right to file case in the court. In that eventuality, case will check up to what degree there is resemblance or idea registered. However, it is not that all the trademarks get registration. If a trademark involves religious sentiments, it creates confusion amongst the public, or it is scandalous, then it will be refused to be get registered. I would like to say that in India, it is not necessary that all the trademarks must be registered. Under common law, if a trademark is not registered, then also it is protected. However, in that eventuality, proprietor will have to prove that he was the first person who has invented, who has searched a good, or who has started a service. This is known as passing off under the under the Torts Act. This can be protected through the on the basis of goodwill which is attached to the goods or services, as the case may be. This rule is laid down on the principle that no one can enrich himself or herself on the labor of other person. For this, the plaintiff will have to prove to the court that defendant has misrepresented and he has also created confusion in the minds of customers that the particular good or service is not that of the plaintiff, but it belongs to the defendant. And due to this act, the plaintiff has suffered huge loss in his business. However, burden of proof lies on the plaintiff. Sometimes it is very, very difficult to prove that yes, who is the first one, who has manufactured the good or who has created the service. So, to my mind, it is what the person should have to do. They will have to get their trademark registered so that there may not be any type of confusion in the future. Thank you.
Thank you, ma'am, for your enriching words. Now, I request our distinguished speaker, Dr. Deepak Jindal, sir, to honor us with his visionary words on how to deal with the aspects of trademark and what is the scenario of trademark infringement in India.
Sir, you have to unmute yourself.
First of all, my good evening to all. It's a great pleasure to speak in front of Honorable Justice Kannan, from whom we have learned always the right application of law while arguing before him cases in the Honorable High Court. It's a great pleasure, sir. Thank you so much. My colleagues, esteemed colleagues, Mr. Mishra and Mr. Jain from Gujarat High Court and Punjab Haryana High Court, I'm delighted to be in the panel with you. See, global competitiveness has redefined the business strategies worldwide, and the focus has certainly shifted. Am I audible?
Yes.
And the focus has certainly shifted to examining how our knowledge resources can reposition our stand in the world market. It means that process of world creation is changing from resource-based to knowledge-based. That is, it now depends upon the brain power and our ability to create, to sell, to explain, and to solve problems. As a result, in future, the wealth would more and more come out of our brains, and less it will come out of the ground. And the goods and services being created by our brain power would be marketed in the global village. Now, a basic issue need to be addressed is that how can this property of knowledge be protected? And prior to this, we need to think that how the knowledge can be converted into property. Since knowledge is abstract and is not like a car or house, which can be locked and secured against theft. If anyone gains knowledge, it does not reduce that available to others. There are two ways of turning knowledge into property. One way is secrecy, which is used to protect three types of information, namely trade secrets, know-how, and rituals. Another way is intellectual property laws, including copyright, patent, registered industrial design, and trademark legislations and conventions. Markets keep on growing and trade and business go on expanding. Consequently, an increasing number of trademarks are registered all over the world. Trademarks are generally, as my friend Mr. Jain has said and Principal Madam also has said, trademarks are generally words, names, symbols, devices, designs, or other distinctive signs or marks which serve to identify the source of goods or services and distinguish them from those which are sold by others. A trademark will not always reveal the name of the source, but if consumers understand that all of the goods or services sold under a particular trademark emanate from a single entity or from others approved by that single entity, then such mark functions as a trademark. Trademarks also symbolizes the goodwill which a company has established for a product or service and provide protection for company's investment in that goodwill. Moreover, trademarks perform an important role as advertising tools for their owners. They aid consumers also because trademarks represent consistent quality. Trademarks are exclusive rights conferred on the owner. Consequently, the use of trademarks by others without permission in connection with similar goods or services is an actionable wrong because such use is an infringement of the owner's rights. Now, coming to the Indian aspect, the Indian trademark law statutorily protects trademarks as per the Trademarks Act 1999 and also under the common law remedy of passing off. Statutory protection of trademark is administered by Controller General of Patents, Designs and Trademarks, a government agency which reports to the Department of Industrial Policy and Promotion, commonly called as DIPP, under the Ministry of Commerce and Industry. The law of trademark deals with the mechanism of registration, protection of trademark, and prevention of fraudulent trademark. The law of trademark in India before 1940 was based on the common law principles of passing off and equity, as was followed in England before the enactment of the first Registration Act 1875. The first statutory law related to trademarks in India was the Trademarks Act 1940, which had similar provision like the UK Trademarks Act 1938. In 1958, the Trademark and Merchandise Marks Act 1958 was enacted. Then came the 1999 Act, which was enacted to comply with the provision of the TRIPS. Though some aspects of the unregistered trademarks have been enacted into the 1999 Act, but they are primarily governed by the common law rules based on the principles evolving out of the judgments of the courts of law. Where the law is ambiguous, the principles evolved and interpretation made by the courts in England have been applied in India taking into consideration the context of the legal procedure.
तो कैसे करेंगे फिर? सिंपल एंटिस क्या? ठीक है, मैं देख के बोल दूंगा. ठीक 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 ठीक. खुल नहीं रहा तो मैं क्या मेल करूं क्या आपको फिर? ठीक है. ठीक 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 ठीक.
Trademarks, laws and realities of India. Trademark, as defined under Section 2B of the Trademarks Act 1999, as trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others and may include shape of goods, their packaging, and combination of colors. With effect from 6 March 2017, the new Trademark Rules came into existence. The intention was to simplify the whole trademark registration process and make it hassle-free work, quick. Some of the features of the new rules are: sound marks are made registrable, 3D marks are also made registrable, e-filing is promoted, provisions relating to well-known mark, separate fees structure for an individual, startup or small enterprise and for others. It also expedited the process of application and registration thereof. Now, what are the remedies in case of trademark infringement? The Indian courts have tried several cases of trademarks and copyrights over a period of time, and the judges are now well versed with the issues in this area. The courts have been very pragmatic in interpreting and enforcing trademarks law, keeping pace with modern business practices. blanket search and seizure orders. Both civil and criminal remedies are available for taking action against infringement of a trademark. However, unlike China, currently there are no administrative remedies available in India for enforcement of trademarks. Therefore, IP holders have to approach either civil courts for filing civil suits for trademark infringement or passing off and magistrate court to file a criminal complaint. Now, what is the law of passing off? As per the Indian Trademarks Act, rights of a person to institute an action for passing off remain unaffected and not curtailed by any provision of the Act. In other words, in order to make out a case for passing off, it is pertinent to file strong evidence to demonstrate that the plaintiff has established a goodwill or reputation in connection with a business, profession, service, or any other activity among the general public or among a particular class of public. Now, what are the criminal remedies? Offenses under the IPC are divided under two headings: cognizable and non-cognizable. Now, the essential difference between the two categories of offenses is that of non-cognizable offenses, the punishment is less than 3 years and no arrest is made by the police at the time of the raids. The cognizable offenses are more serious offenses. The offenses under the Trademarks Act are cognizable offenses. There are provisions under Customs Act also and few other laws also which are there to come to the assistance of the persons who are suing for the infringement of trademarks. Thank you so much.
Thank you, sir, for the enlightenment. Here now is our next dignitary, Advocate Bhagyodaya Mishra, sir, to give his inputs about the methods of opting trademark. So you have to unmute yourself.
Yeah, doing that. Yes. Good afternoon to all. Good afternoon, Lordship, Karana Lordship, my learned friend Alok from Punjab, my learned friend Deepak from Chandigarh, Principal from the Principal Monica Sharma, respected to all, and welcome to all participants, those who are interested to take the participate in the program. What is the for the trademark infringement? The trademark infringement, the Trademark Infringement Act 1999, the legislation that protects trademark in India, the act laid down the rule dealing with the regulation, protection, and penalties against infringement regarding the trademark. Trademark are given the status of the intellectual property across the global. There are many organizations, both international and the national, that endeavors to protect intellectual property such as trademarks in India, and the organizations that deal with the protections of trademark are the Indian Patent Office, administered by the Control General of Patents, designed on the trademark. In simple word, trademark infringement is the unauthorized usage of the mark that is identical or deceptively similar to the registered trademark. The term deceptively similar to here means that when an average consumer look at the mark is likely to confuse him, her on the origin of the goods or service. Type of trademark infringement. There are two types of trademark infringement. Direct infringement. Direct infringement is defined by Section 29 of the Act. There are few elements that have been to be meet a direct breach of the occur. They are the follows. Used by the unauthorized person. This means that the valuation of the trademark only happens when the mark is used by the person who is not an authorized by the holder of the registration trademark. If the mark is used with the authorization of the holder of the registered trademark, it does not constitute infringement. identical and deceptively similar, the trademark used by the unauthorized person needs to either be identical to that of the registered trademark or deceptively similar to it. The term deceptively means similar here only means that the common consumer may be confused between the mark and the mark thing. The theme being of the same, the optional words here being may is only need to prove that this is a possibility and does not require to prove it actually happens, as long as there is the chance of the misconception of the mark enough providing the infringement. Registered trademark, the act only extended the protection of the trademark that have been registered with the trademark registered in India. In the case of breach of the unauthorized mark, the common law of passing of used in the settled disputes, it is the tort law that used with injuries of and damage is caused to the goodwill associated with the activity of the another person, of the group, or the person. Now, the class of the good of the service for the infringement of the trademark, the unauthorized use of the mark has to be used for the propaganda goods or service of the fell under the same class of the registered trademark. Now I tell the indirect infringement. Unlikely direct infringement, there is no previous in the act that deal with the indirect infringement specially. This does not mean that there is no liability of the indirect infringement. The principle of the application of the indirect infringement arises from the universal law principle. It holds the uncountable only when all principal infringement, but also anyone that abet, induce, or direct offense of the infringement. There are two types of indirect infringement. Vicarious liability, according to section 1(4) of the act, the company commit an offense under this act, then the whole company will be liable. Therefore, not only the principal infringement, but every person responsible for the company will be liable of the indirect infringement, except for a person who acted in good faith and without the knowledge of the infringement. The element of the vicarious liabilities are when the person or control the activity of the principal infringers, when the person knows the infringement and the contributors to it, when the person may devise financial gain from the infringement. The only exception of the various liability of the company infringement in when the company is acted in the good faith and had no idea about the infringement. Contribution infringement, there are the only three basic elements contribution infringement: when the person known of the infringement, when the person materially contributed to the direct infringement, when the person induced the principal infringers to the commit infringement. In the case of contribution infringement, there is no exception of the three exit of no changes of the contribution infringement act of the good faith. Penalty of the trademark infringement. In India, infringement of trademark is a cognizable offense, which means that the infringement may be also face criminal charges along with the civil charges. It also not required by the Indian law for the trademark to be registered for a institutional civil criminal proceeding. As a mentioned before, this due to common law, the principle is passed off. In the case of trademark infringement, the court may be award the following remedies: temporary injunction, permanent injunction, damage. Accounting the profit, damage is the account of the profit gained from the infringement. Distinction of the good use of the infringement mark, cost of the legal proceeding. In case of the criminal proceeding, the court may be directed the following punishment: imprisonment for the period not less than 6 months or may be extended to the 3 years. There is a slabs of 1 to ABC is there. Some of the cases 1 for 2 years is there, as 3 years is there, and to 2,50,000 and above, and 3 years imprisonment is there. That's all, Your Lord. Please pass to other speaker to the convener. Please, Your Lord. I deeply oblige all of you.
Thank you, sir, for sharing your profound knowledge. Now, I request Justice Kannan, sir, to grace us with his presence and articulate knowledge on how to deal with the problems and Indian laws and remedies on trademark infringement.
Yeah, it's a pleasure to be with you all, and nice to be seeing Alok Jain and Deepak Jindal, persons who have practiced before me. I see the previous speakers have brought so much of textual knowledge, probably running through the sections, speaking to you about the content. So I thought I'll do what I am normally used to doing in the court. that I only listen. I make the other persons read up and come before me. So here also, I'm not going to be reading up to you any particular provision of law or what this contains. I would rather fill you in with some details about the concept of what this is all about in the particular and also to address what remedies are available. I suppose that is what, if an infringement takes place, what do you do, is what I think the speaker wanted me to say. Just remind yourself about this. Our Trademark Act of what you have is a kind of an exception. The state policies normally frown against any monopoly, anyone having something to do all by yourself, and then you control the market. It is frowned upon. In fact, you have monopoly restrictive trade practices. There is a law against it. But then patent, for instance, this is again a right which somebody has of an invention. And it provides for a particular period. If you have a patent for 20 years, you will probably have a right to exploit it. And beyond that, you don't have. Or when you're talking about copyrights, you have again a certain period, 70 years or so, that you have a copyright, and that will be possible for you to protect your copyright for a particular number of years. But trademark gets to be a kind of an exception. It can be for any number of years. Though the registration lasts for 10 years, you can keep renewing it for any length of time. So trademark is somewhere kind of an exception to the other known methods of protecting some of your inventions. And I was also wondering how come we didn't have any legislation till probably as late as in 1940 you had. What was all the trademark? Was there not a trademark at all? In fact, looking at even the Declaration of Independence and what the US did when the constitution makers were bringing out a law, you have in Article 1, Clause 8, where it says to promote the progress of science, what you need to do, and to protect the invention and the exclusive right to writings and the discoveries. You had a concern, even in the constitution, a clause being brought in there. But we have nothing like a constitutional protection. If you're talking about just some time back, one of our speakers talked about this is a right and intangible right. A right to property, where do you think it exists in our constitution? What was originally stated as a fundamental right under 19F was taken subsequently. Right to property is not any longer a constitutional right in that sense, except that you have it provided under Article 300, that no property can be taken away from you except through a process of law. That's all. So therefore, trademark, you must understand, first of all, you're not talking about any large right. This is a protection which the law gives to you, and also avails to you certain right of action if there is an infringement. So in that context, you will know. And then why do we protect it? What is the need? The idea is that you protect it because somebody is inventive, somebody has given something very unique, and therefore protect it. And surprising, you know what? Arbitrariness is something usually unacceptable in law, but this is one law where arbitrariness is promoted. For instance, if you call a computer Apple, it is acceptable. But then you call a computer and you want to register a name called as Compute Product or something, probably a trademark will not be accepted. It has to be arbitrary. It has to be in some way inventive. So therefore, a kind of a paradox of what you might see, it is the very nature of things that it is not suggestive. A trademark, what you have is not immediately suggestive of the product itself. It cannot be. And so therefore, that is an arbitrariness is in some way encouraged here. And the protection is given because I believe it was somewhere in the 15th century, a barber's pole. He stuck up a pole there in UK and said, this is the way to go to the barber. And that was how it was all started, a kind of a recognition of what came through. But then Indians would always have something to say. We started first. So therefore, in Mohenjo-daro, and we had all those artifacts brought out, and they said that manner of stamping your product, a manner of identifying your own product. It's a method by which we registered our first trademarks. That's how it used to say. And traders at the time, probably, and the Sumerian traders from Mesopotamia, they all had some marks to identify that it came from a particular place. So that which came, identity was required to be fixed. And if somebody is trying to exploit it, your own product, it must be stopped. So therefore, here you have two things about how the infringements are protected. First of all, it says there is a provision there in the Trademark Act. It says under Section 27, if it's no right of action of injunction will be possible to, you can't complain of infringement for an unregistered trademark. Do you understand, therefore, trademarks would all require to be registered? No, it's not so. Registered trademark provides to you a scope for a prima facie proof that it is inventive, it is original, and some authority has seen that if you have registered, you can complain of somebody who is trying to bring about a product under the same name or deceptively similar to that name. What is deceptively similar? What a reasonable person can see as be deceived by such a thing. It can be by a color combination, by the way the words are written, by the way the logo is prepared. There could be so many visible presentations of what there could be. 1999 Act, when it came, it was not merely a product. Originally, trademark was used for goods, and then they added goods and services. Was that not, therefore, trademark for service? It was. What do we understand by trademark for goods and services? What is service? Supposing there is a physiotherapy clinic or somebody I have, something I have. I don't sell products there. I have probably I have a logo made for that, or a attorney's firm, for instance, with some specific kind of visible representation. Therefore, a service provider who registers his mark, he wants to protect, he or she wants to protect the way it is given out to the public. And if a person is registered and somebody else is now trying to come into the market and make it appear that he also has goods or services to offer the same way, then you'll be able to prevent the person from doing that. What you need to know is if there is an unregistered trademark, the person has no registration, then his trademark is offended by somebody else trying to secure a registration. What do you do? Then he has to come before the authority, and then he can still complain of infringement. How does he do? He applies to the authority and say, now, why do you rectify this or remove this? And he doesn't have a trademark, and therefore he has got it registered with us. I have a pre-existing use. I have been a user even before he came into the market. So therefore, have it rectified, have it modified. This is what a person can do. There could be several differences. They can say there is nothing particular, there is nothing inventive about it. This has been normally used by several types of persons. In fact, one of the earliest decisions was in the year 1964, where Durex, a London rubber company, came for a case against a Calcutta company here. Durex was a contraceptive, male contraceptive. So there was yet another product about London. They also had a Durex, and that was for female contraception and what could be kept inside as a service. So therefore, it couldn't be easily done. Anyone knew that there was a difference in what the product was. They said, therefore, you won't be able to prevent that person, and therefore you won't get that benefit. Was what was stated in the 1964 earlier decision. So unregistered trademark holder will be able to take action under the authority and then have it modified or rectified and say, no, don't have the name recorded, don't have the trademark recorded, remove that. That is possible. That is possible in Section 7. And even the registrar has so much of powers under that. If he comes to know that he has registered a trademark and later comes to know that somebody else has, though not registered, has a use, a pre-existing use, then he will call for evidence and then have it removed if that is done. There could be another instance of a person who has a registered trademark and is confronted by a person who is having an unregistered trademark, creates a problem. Then there can be a restraint. There is no authority under this act to do something. A person who is not even registered and he comes into the market. What can you do? You will have to only file a suit. So what is available to you is a civil suit, an injunction, restraining the person from using the trademark. What will the court look into it at that time? It will see, is it deceptively similar? Is it very particular? Does it show something which is unique about the product or about the way he has given it out to the public? So all these things will be seen. There could be some trademark which will be universally acceptable. There will be nothing. They could even allow for several persons having the same kind of trademark. That is also possible. You can obtain, if you have a trademark, I can take your permission and use a trademark. You can get that kind of a right to market it, to exploit it in some way. So a trademark infringement, when we are talking about a situation where you'll have to first see this. Is it a registered trademark? Yeah. If it is a registered trademark, you have a claim for an infringement. You can ask for an infringement. If it's not registered, you don't speak about a restraint for infringement. You can only take action for passing off. Now, I'm introducing some new expressions. I believe that there are persons who are trying to understand the trademark law for the first time. When we are talking about the infringement, we are talking about some person who infringes. You understand the English expression. Person who infracts, a person who causes some obstruction, who does something and he has trenched upon your area of activity. Therefore, you can prevent the person. That infringement power of what you can complain is available only to a registered owner. If he is an unregistered person, you don't talk about infringement action. It's only a kind of expression which is slightly different. You pass off some goods as though it is your own. That is what it means. So therefore, an unregistered trademark holder and doesn't take action for infringement for an injunction. On the other hand, he seeks for injunction for passing off. He is trying to pass off his goods as if it was his, it is actually mine. My goods are sought to be passed off by him. So that is a kind of action. So we employ different expressions. We employ different forums for approach to complaint of breach. That is what is essentially the way we deal with it. So now there could be situations where infringement, there could be limits. There are some limits of infringement. To what extent it can be done, the Act itself contemplates. And you will also know that some of the goods, as I see, some goods can be, it is well-known trademark, if there is something like that. Then even it's a different category of goods. For instance, Benz had a case, and that was where it started. And 1999 Act also recognized that well-known trademarks. You have a separate schedule where it contains how a particular product has been in industry for a long time, and people associate themselves with a particular company. Somebody in India was manufacturing a vest, and it was called Benz. And when the German car manufacturer came for a complaint and said, no, he can't use this, the response by the vest manufacturer was, I'm manufacturing vest, for God's sake. You're manufacturing a car. There is a scope for anybody to complain of deception. Why would anyone be misled? But the court didn't accept it. Everyone knows Benz is such a popular brand. People know it to be a German company manufacturing cars. And they could be thinking, probably they're expanding the business. They're coming to India to manufacture vest for Indians. So therefore, that's how they said. So it all started a new understanding to the subject itself. And therefore, we have some popular brands, universally known. So they, for instance, Infosys is seen in the schedule as one of the products. 7 o'clock, a shape razor. It's by Gillette. So therefore, well-known marks are now recognized as something where even without reference to a particular category of product, you can cut across any other category. Because when we're talking about trademark, we talk about trademark for a particular category. You have various classes. When it is registered, the registration is for a particular class of the products. So therefore, but when you have some other product, you can still prevent if it is a well-known trademark. That will be good. So this I thought are some of the basic concepts. My attempt has been now for you, not so much to read the sections, not so much to tell you what the content is, but to explain to you some concepts of how you understand the Trademark Act itself and what causes a right for you to approach a court. When can you seek for a restraint? When you seek for a restraint in a civil action, you'll be able to prevent all the trademark. You can have a commissioner taken there to gather, collect all the things of what are there, seize them, and then take it there. You can ask for damages to be assessed by the sale of the products which are deceptively similar to mine. What is the kind of profit which has made? All that must have come to me. Therefore, I will take that. Now, I've lost some business somewhere. People thought that this is not a good product. Why this kind of a low product I will not buy? Some persons buy a poor quality of the other person who was trying to deceive. He has taken some market from me. Another, some persons have left me from my business because of the poor quality, and they were deceived by their product. They thought my product will also be bad. So we can estimate that loss also. So there are various types of actions possible. You can prevent him from doing some action in future. You will not be able to sell. You can seize the person from selling the product. You can assess the damages of what has entailed to you by another person selling the product by its name. So these are all the various types of actions which are possible when there is an infraction of your right as a trademark holder. So with this, I'll just conclude for the present, provided, however, I have time enough to come back for any questions. Thank you.
Thank you, sir. It was a great opportunity to hear your thoughts. We are grateful for the time you took to share your thoughts. Thank you, sir. Thank you to all the distinguished speakers and dignitaries for their articulate knowledge and expertise views on this session. So with this, we'll go ahead with the question and answer session. I would like to invite Garima to start with the session.
A very good evening, everyone. Now is the time for question and answer session. The questions will be asked from our distinguished panelists respectively. So the first question that we have is for our Honorable Justice Kannan sir, that what is the procedure of filing complaints when trademark is infringed? Please, sir.
Oh yeah, just now I think I was telling you what is the procedure for lodging a complaint. You said there is no procedure actually. If there is a trademark which I have, let me assume I have a registered trademark. Yet another person is having a trademark registered again with the same kind of a thing. Normally, a registration of a trademark goes through a kind of process. An application is given, then a particular time limit is given inviting objections. And then this is also put up in a journal, that is a trademark journal, which will show that we have examined this, we have seen from when this has been in use, all that information is given. We are of the view that there are no valid objections, or there are no objections. We are going to register this trademark. This is what they will say. And somebody can have a look at that and say, no, this is not correct, this is like mine. And then an investigation, an inquiry will go. Then they will see whether a trademark can be registered or not. So this is what will happen. If there is already a trademark which is registered, yet another person has secured a registration, you have not looked at it, you have not seen the advertisement at the time, you can come to the authority again and seek for rectification, which I was talking about under section 57. It allows you to cause a rectification of what is already, when I have a trademark, another person also has registered a trademark which is deceptively similar. I didn't take notice of a publication which had come in the trademark journal, and I did not oppose it at the time. I don't lose out anything. As soon as I come to know, I can seek for rectification. Within a particular time, I need to come to the authority and then seek for restraint. So therefore, that is the kind of action. Actually, what do you do when, how do you file your objection to an infringement of trademark? I would say under the Act, you have nothing except when it's only against yet another person trying to register a trademark. When you have already a registered trademark, you seek for rectification. Or if you are an unregistered trademark owner and another person has registered it, which is an infringement, you can seek for rectification. Or if you are a person who is a registered trademark owner, another person is unregistered, you can't have any remedy under the Act. You'll have to go to a civil court, seek for a restraint, and say, now he's trying to push a product like mine. There is an infringement. I have a registered trademark. Therefore, I have this is being infringed. I have a right of action against you by an action for injunction by damages. So therefore, you will go to civil court in a situation where you are making an action against an unregistered trademark. If he is a registered person himself, if you are a prior user, you will have a right of action under the Act. If you are also a registered trademark owner and yet another person is registered and you had not seen that previously, you had not caused an objection, you still have a remedy under the Act. So it all depends on whether you're trying to take an action against a registered trademark owner or an unregistered person. That will determine the place where you will take action. So this is my response to your question.
Thank you so much, sir, for your kind words. The next question that we have is for Advocate Bhagyodaya Mishra, sir, that what are the elements and the consequences of trademark infringement?
See, if any person, without taking the registration of the trademark, they're using, and the wrong information has been given, so the criminal offense has been registered against them. This is a one point. Second point is there, if any person, if any company is there, company has been registered and which has been, but not be earlier some other company has been registered in the same product. And this company also coming in the market that telling that this product is mine. And then afterward in the future, when they come in the know that the company has not been taking the trademark, then the offense has been made against him. Under section 134, they must go to the civil suit, file the civil suit. The criminal offense also be there. So this is the remedies are there to file the infringement if suppose such thing has been done.
Thank you so much, sir.
Please.
The next question is for Dr. Deepak Jindal, sir, that what are your views on the future of trademark in the upcoming era?
See, a trademark registration or a trademark is an important asset, basically, in a global and online economy. I completely agree with Justice Kanan, sir, that how come there were no laws till 1940? Were there no trademarks? So we can see that trademarks have been used since the very earlier times also. And owning a trademark can increase a company's value, basically. Company's value to potential investors or purchasers, and allow a company to secure rights in a mark before it begins to make the mark. So there are various benefits also for trademarks. Trademarks are an effective communication tool. They makes it easy for the customers to find you. The trademarks allows businesses to effectively utilize the internet and social media. Also, trademarks they can bring hiring. They can make hiring easier, and trademarks they never expire, basically. So I see that there is a great fortune for trademarks in the coming time.
Thank you so much, sir. The next question is for Advocate Alok Jain, sir, that whether Indian laws are enough for the trademark infringement or they need to be modified.
That is for the legislation to see, but as a lawyer, we go by what the law is today. So as far as the law concerned, I feel that we have a very good law. Only the problem is implementation. Section 29 very categorically details out what would amount to infringement. And Justice Kanan very nicely emphasized what is the difference between infringement and passing off. If your trademark is registered and somebody uses it without your knowledge, without your permission, it is infringement. For that, you can go under section 134 and file a suit against that person on two counts. One, to stop him from using it, and secondly, seeking damages from him for using it for whatever period he used it. And in case your trademark is not registered, then you file a suit in the civil court for passing off. So the laws are there. I feel the laws are, yes, but law is something which is ever changing every day, because many other countries are very extensively into registration of trademarks. Even if they're not doing anything, there are companies made only for registration of trademarks. They're not doing anything. And subsequently, then they sell these trademarks. Trademark itself has become a good for them. It has become a product, it has become a service. So yes, today the laws are there, but yes, we have to keep our actions open that might need to change it in the coming times. Because of the e-commerce, because of this digitalization, there's a huge market. You will never come to know that probably Nike shoes are being sold in the showroom for 3,000 rupees and on online site for 1,000 rupees. So how is it possible? You need to understand that. Or for matter of other things also. So this e-commerce, the thing which e-commerce is brought in, I think personally that yes, the law has to evolve, and change is the only permanent thing. You need to change. You need to change for time. You need to improvise. And as and when the situation would arise, I think we would definitely upgrade our laws. But as of today, I think we have a good law.
Allow me to add a few things there to what
Yes,
Alok said.
sure, sir.
Yeah. This legislation, Trademark Act of 1999, it has brought about substantial changes. Now there is literally a kind of a global parity in terms of intellectual property laws. You have in every country something similar, because these are all driven through international conventions. They set the agenda for you, what each one has to do. How do you protect the intellectual property rights? So these are truly universal laws. So therefore, when you're talking about what do you see, is there a scope for a change in India or something, or what Alok says, it's fine with the law, what he says. The problem has been implementation. Therefore, I have something to say. So implementation in India, we have always suffered, not because of any inherent difficulty or inability to do with the work, but just the numbers, the sheer numbers of what we have in India on anything, be it in the hospital or the courts. It's just kind of a huge number. But if we think everything must be working only through court systems, then we are completely mistaken. So when we are talking about law, how law is effective, is this trademark law in India sufficient? The law is sufficient, but how do you see that the rights of parties are adjusted? Where there is a conflict, somebody who makes an infringement, and then you have a right of action, what do you do? There could be a honest in fact, the act itself contemplates honest concurrent user. There could be something like that. Somebody else is doing something very similar, even without reference to it, not knowing that there is a product which is registered like that. So there is a lot of scope for discussion and readjustment of rights. And that is where perhaps the ADR systems can come in a big way. In Punjab and Haryana, there are no big factories in any sense. But then Delhi, there is a vibrant intellectual property case law, and cases go there. There you will find that the mediation and center, literally in every second case, it's referred to mediation, and it works out well. So adopting ADR systems to complement how the court functions, you'll probably find that the law can be effectively used. So on the manner of how we use the law, I thought beyond the courts, there are other immediate adjunct systems we must be trying, is what I wanted to add. Thanks.
Well, I'll just share a small experience, sir. I was counsel for this company known as Sony, and their trademark was blue color background and white color they use for writing SONY. Now this thing is registered in 136 countries. And somebody in a village near Pinjore, there's a place near Chandigarh, Pinjore, he opened his small shop of Sony jewelers. and it was on the main road. And once a person of very high dignitary of the company was traveling to India, and he just passed through that road and just saw Sony Jewelers. That was the time I came to know that Sony has registered its trademark in all the classes. From a pin to a plane, you cannot use the word Sony anywhere. So if that is the level that they play, that internationally they want to play, then definitely
that's an answer. That's an answer, Alu. Well-known trademark cut across all categories. So therefore, otherwise, how would Benz have an action against somebody who makes a vest? So therefore, Sony is that kind of a brand, a well-known brand. And even without registration, with registration of just electronic products, they may be able to stop that. So that is what 1999 law protects you.
Correct. Correct. That's it.
Yeah. Correct.
Pleasure being here, sir. Thank you for making us more wise.
Thank you so much, sir. And the last question that we have is for Dr. Monica Sharma, ma'am, that what is the difference between trademark infringement and the patent infringement? Please, ma'am.
Thank you, Garima. As we have already discussed, I think in trademark, there are two types of, we can protect our trademarks by two types, registration and through unregistration also. Therefore, if your trademark is registered and another person tries to use that, then there is infringement of that, statutory infringement of that, and person can move to the court. And if there is it is unregistered, in that eventuality also we have already discussed that there is passing off, then you can move to the civil court. Is that clear? That is also infringement. But in the case of, that means you have to prove that yes, who was in passing off, you have to prove who was the person who first manufactured the good or who first started the service. But in case of patent, it is not so. If you have invented something, but you did not get patent over that, and another person has invented the same thing after you, but that person has got patent of that, then that person will become the proprietor. The first person cannot challenge that I was the first person who invented that, therefore I have right over that. If he starts using that, then that will be infringement.
Thank you, ma'am. Since the question and answers rounds are completed, but there is one question that is for Justice Kannan, sir, which has come away along from Andhra Pradesh from a student. That is, what is the secondary liability in the trademark infringement?
Sir, kindly unmute yourself.
Please repeat the question. I couldn't understand.
Sir, the question is for you, what is the secondary liability in the trademark infringement?
Probably you'll use some expressions like the secondary liability. As I see, the liability is, if you are a registered trademark holder and you're taking an action, the liability for the person is restrained from him to do what you're already doing. You can't promote a product or what you have. What is the secondary one? I'm not too sure. Probably some of the persons who are daily in practice, Alok, will be able to answer. I don't know what we understand by a secondary liability. Please, honestly, I wouldn't know what a secondary liability is. I would only see.
Lordship.
Yeah.
Then Lordship, what is there? If suppose anybody has been registered and some other person is using the same product has been there, same symbol has been used by him, that is second charge will be there, I think. And he also be registered before the trademark.
That's why I said, where there is a registration, yet another registration has come about, you'll have to seek for rectification. That is the right which you have.
Yeah, Lordship, earlier one person has been taken the trademark, which has been registered by him. Later on, but the other person has been also be registered. And
That's
it is come in the...
In which case, your only remedy is to have that rectification done through an application file, saying now he has also registered. He can't have it registered. That is the way you should act.
For the purpose, we have to file before the Trademark Commission before the for the challenge. Please,
if there is any other answer from any of our panelists, please go on to it. I'll deflect it to any other person. Thanks very much for Mr. Bhagyodya for that.
Please, Lordship. I deeply oblige the Lordship. I deeply oblige for that.
Thank you, sir.
Thank you so much, everyone. Now, due to the paucity of time, we will not be able to come up with all the questions. I hope we have answered almost all of them. But if still anyone is having any doubt, you could mail us on our email ID, and that will be answered within 48 hours. Now, I request Saksham, our organizing head, to propose a vote of thanks.
A very good evening to all the worthy dignitaries, principal, professor, advocates joining us from different states and different honorable high courts. Honorable Justice Kannan sir, Advocate Alok Jain sir, Dr. Deepak Jindal sir, Advocate Bhagyadev Mishra sir, and Dr. Monica Sharma ma'am, worthy principal of Rayat College of Law. A very good evening to the dignitaries. It's my privilege to have been asked to propose a vote of thanks. I, Saksham, organizer head of the Rayat College of Law virtual session 4.0 on the successful completion of Rayat College of Law virtual session 4.0, propose a heartiest vote of thanks to Justice Kannan sir, Advocate Alok Jain sir, Dr. Deepak Jindal sir, Advocate Bhagyadev Mishra sir. I must not forget to thank especially all our dignitaries, Justice Kannan sir, Advocate Alok Jain sir, Dr. Deepak Jindal sir, and Advocate Bhagyadev Mishra sir. I would also thank Dr. Monica Sharma ma'am, worthy principal of Rayat College of Law, who supported us, helped us, and gave us this opportunity to organize such a great event. I would also thank the official knowledge partners of the event, the Locket, the Leg Streets, and the Kanuni Sahara. As it is been rightly believed that no event is successful without the attendees, so I would also like to thank the constant and patient attendees. And regarding the e-certificates, it's a request to kindly fill the feedback form, because after filling the feedback form, the e-generation of the certificates would be done. Since after completion of this successful webinar, we would be back with the last webinar, which will be the concluding webinar of all the webinars, which is a 2-day dialogue session on the topic Scope of Women in Legal Profession. The dates for the same are 1st and 2nd July, and the time would be 4 to 5 p.m. I would also thank the organizer head Pratibha and organizing team members Garima and Mannat, without whom this dream would have not been successful. Once again, I thank honorable dignitaries, Justice Kannan sir, Advocate Alok Jain sir, Dr. Deepak Jindal sir, and Advocate Bhagyadev Mishra sir. Now I seek the permission of the honorable dignitaries to kindly close this session webinar.
Thank you.
Thank you.
Thank you.
I, Saksham, organizer head of Rayat College of Law 4.0, officially close this webinar.
Thank you, sir. Thank you.
Thank you, Justice Kannan. Thank you, Justice Kannan, sir. Alok Jain, sir, thank you. It's grateful, sir. Thank you, Deepak Jindal, sir. Thank you, Bhagyadev, sir. Thank you, Principal Ma'am, for helping us so much.
Thank you.
Thank you.
I request the organizing members to please stay and kindly leave all the attendees to kindly leave.